If a parole officer issues conditions of release that bar a sex offender from accessing pornography or nudity or erotic material, is that unconstitutional? To find out, you have to read Karlin versus Stanford, but it's 5 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases and I try to do it in 5 minutes or less. This is the episode on the case of Karlin versus Stanford. The citation for this case is 2024 New York Slip Opinion 04048, published by the New York Court of Appeals on July 31st of 2024. The issue in this case is whether it's unconstitutional to impose a condition of parole that prohibits sex offenders even from accessing materials depicting sexual activity, nudity, or erotic materials. To understand and appreciate the context of this case, the background that's helpful to know is that under Executive Law 259C, the Board of Parole has the ability to impose conditions of release for people. So if a person's sentenced to prison for, let's say, 20 years, but they're released after they've done 6/7 of their time, for example, and they get released into the community, the parole department, the Department of Parole, may issue conditions of release. Now, they still owe some time back. So if they violate the conditions of parole, parole can say you can conduct a revocation hearing, say you violated a condition of release, and send them back to jail to finish their full amount of time that they owe. Okay? But they have the ability under 259C to impose conditions of release that are appropriate based upon what they've done and what would protect the community and help rehabilitate them. The other thing you have to know is that the First Amendment to the Constitution of the Bill of Rights states Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech. The freedom of speech is a First Amendment issue. It's a fundamental right of all people in America, all citizens. The U.S. Supreme Court has held that the First Amendment to the Constitution protects the right to view and access pornography. Okay? Not obscenity and not child pornography. Those are the two exceptions to pornography that are not protected. But what is protected is pornography. The concept of pornography is protected under the First Amendment. There's a case called Sable Communications of California versus the FCC, which states that an outright ban on pornography other than obscenity or child pornography would violate the First Amendment unless it served to promote a compelling interest and was the least restrictive means to further the articulated interest. Okay, that's the background. What are the facts in this case? The facts are that in this particular case, the petitioner was the defendant, but we'll call him the petitioner here. The petitioner was convicted of multiple criminal sexual offenses involving incidents where he allegedly molested several people, involving several male children when he was a teenager. Okay, so this is a person who had an incident with sexual abuse with respect to multiple children. The petitioner was conditionally released from prison to parole supervision in September of 2018, and he was adjudicated a level 3 violent sex offender. Amongst other things, the conditions for his release included a condition that barred him from owning, possessing, purchasing, having control of any computer-related materials without express written permission from his parole officer. So a blanket ban on a computer access, okay? But then the petitioner decided he wanted to go to college, which is good because it helps rehabilitate, right? At that point, when he enrolled in college classes, he sought permission to get a computer, which would have violated the ban. His parole officer approved the request subject to a following conditions, which the petitioner certified that he accepted and read, okay? Those conditions included, okay, you can have a computer, but I will provide all business, personal, and internet service provider information to my parole officer. I will provide all user ID and passwords, a whole bunch of conditions. The last condition, condition 8, said, condition 8 said, I shall not view, access, possess, or download any materials depicting sexual activity, nudity, or erotic images. Less than 5 months later, there was a random search of his computer, and they found that he had violated that. They did a revocation hearing. He pled guilty. He went to jail for another 22 months. For a 22-month hold, and he appealed. Basically, he raised an argument under an Article 78 proceeding saying this whole revocation hearing, it violates my constitutional rights to access pornography, right? First Amendment right to access pornography. You violated it and said I can't, and you're revoking my parole for that reason. Supreme Court found it was not an unconstitutional violation. It appeals to Appellate Division, Third Department. They affirm it. And now it goes to the Court of Appeals. And here the Court of Appeals says, yes, okay, parolees do have First Amendment rights, okay? They do not lose their First Amendment rights completely, but they remain under penal supervision. They're actually under the legal custody of the Department of Corrections. Even though they're in the community, they are still in the legal custody of the Department of Corrections. And so the Department of Corrections under 259C can issue reasonable, penological, which means based upon correctional principles, conditions. And so while parolees have First Amendment protections and they have more freedom than people who are incarcerated in many ways, this does not mean that he has full First Amendment rights to do whatever he wants. It's not an unconstitutional violation for the parole department or the parole officer to initiate prohibitions on access to pornography. That's essentially the holding from the Court of Appeals. They say the petitioner failed to establish a violation of the First Amendment rights. And even though he claims it would bar him from going to a museum or watching a film it's not pornography related, but has nudity or erotic material in it, this is not a constitutional violation. It's not overbroad, and it does not impair his constitutional rights. And that's the case of Karlin versus Stanford. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.